Hello, I'm Bill Peterson, Minnesota probate attorney. One of the questions that comes up oftentimes with our clients is what happens when we go to probate court? And that's the question we'll look at now. In Minnesota, if the estate is one that involves real estate, or if the assets are more than $50,000, then in most cases there must be a probate proceeding. This is true whether or not there is a will. The probate process is begun by a petition, which can be filed by an heir or a person who is supposed to inherit under the will, or in some cases a creditor. The petition can be filed anytime 5 days after the death and up to 3 years later. The probate must be begun in a county in which the decedent had his or her residence. The petition identifies certain facts about the decedent, summarizes his or her assets, and nominates an executor or personal representative. Now, these two terms mean the very same thing. Depending on the case, the probate may be what we call informal in front of the probate registrar of the county, or one that's called formal in front of a district court judge. When a probate is begun, there must be written notice given to the heirs and creditors of the decedent. There must also be a published notice in a legal newspaper of the county where the probate proceeding was filed. Also, there needs to be notice to the government public assistance agency in case the government has a claim for reimbursement. This is required even if the family is certain that the decedent never received public assistance. There are 17 tasks that the executor needs to do, usually with the help of an attorney. When the case comes before the probate court, the court reviews the contents of the petition. If there is a will, the court decides whether it is valid. Next, the court looks at the nominated executor to see if he or she is a suitable person to take on these duties. If an heir or creditor wishes to challenge the petition on any of these issues, the challenger is entitled to a trial and to have the court decide how the estate will be handled. If there is uncertainty or a challenge to the nominated executor's ability to handle the estate, the court may require that the executor obtain a bond to assure that he or she handles the estate properly. A bond is an insurance policy to guarantee that the creditors and the heirs will not suffer financial loss because of a creditor's possible neglect or wrongful acts in administering the estate. The executor gathers the assets of the decedent and pays the valid debts of the decedent. The executor can begin selling or setting aside the property for later distribution of the assets of the estate. The proceeds of the estate must be preserved in a separate estate account at a bank or other financial institution. Within 6 months of the beginning of the probate, the executor must file an inventory with the court. This is a listing of the assets that the decedent had at the time of his or her death. The creditors of the decedent have 4 months to file a claim for the debt they claim to be owed by the decedent. If a creditor fails to file within that time, the estate may be free from the obligation to pay that debt. If the executor questions any claimed debt, there are time limits in which the executor must file a denial of the claim. The claimant then can demand a hearing on the validity of the claim. The creditor and the executor can each present to the court their arguments about whether or not the claim should be honored, and the judge then decides. When all of the assets have been collected and the time has passed for making claims, the executor needs to prepare a final account and propose distribution of inheritances. may be necessary to have the court approve that as well. In any case, it is often desirable to have all the heirs and persons entitled to bequests to consent to the distribution proposed. If the probate is one that's called supervised, it may be necessary to have the court approve the accounts and transfers of the property. With the help of an experienced legal counsel, a probate proceeding can be reasonably fast, economical, and worry-free for the family. I hope you found this information helpful to you and your family. I'm Bill Peterson, Minnesota probate attorney. Hope to talk to you soon.